last minute preparation and get started. I work on the Financial Solutions Lab, and I am happy that we are hosting Abdul Bassett for our FinTech Expert Series. Today's conversation will focus on FinTech patents, of which Abdul is an expert, so we're happy to have him join us. A couple of administrative items before we get started. This presentation will be recorded. You can find the recording on our website where we will post it. That'll be the Financial Solutions Lab website. If you haven't done so already, if you could please mute any mic, speakers, or phones, just to avoid any feedback during the presentation. And we will have ample time for questions and answers. So feel free to chat your questions into the GoToMeeting chat box, and Abdul will answer your questions at the very end of the presentation. So feel free to make notes or to send in your questions as we go through the presentation. So for those of you on the line who are not as familiar with the lab, the Financial Solutions Lab is a $30 million 5-year initiative managed by CFSI with founding partner JP Morgan Chase. And the purpose of the lab is really to support early stage entrepreneurs who are improving consumer financial health through new and promising innovations. We have run about 2 programs thus far, working with 18 early stage entrepreneurs in total. And we are about to select our 3rd class. So our current application cycle is currently open. So for any of you who may be interested in applying or who know of FinTech entrepreneurs who may be a good fit for our program, we would love to hear from them. You can find out more information about our application process at our website at financialsolutionslab.com. And the deadline will be April 27th. So with that, I am happy to turn it over to Abdul Bassett for our presentation today.
Yeah, thank you, Maria. I appreciate the time that you're giving me and the opportunity to talk about a very important area of intellectual property law that pertains very much to FinTech and financial technologies in general. Before I begin, as a lawyer, I have to do a disclaimer. This is actually the most words you're going to see on any single slide throughout the whole presentation. Don't worry, the rest of the presentation is not going to be like this. But this is just to let you know that the document and presentation is for informational and educational purposes only. That the views being presented here are only the views of myself and the law firm of AQ Bassett, and not of the Center for Financial Services Information, the clients of my law firm, or any other organization. Anyone who's involved in this presentation should not act or rely on this information without first seeking the advice of an attorney. And finally, in some states, this document presentation may be considered as attorney advertising. And also any discussion of prior results does not guarantee or predict a similar outcome. That being said, today's presentation is about a case that was decided by the Supreme Court in 2014, known as Alice v. CLS Bank. This decision has had a profound effect upon innovations dealing with intellectual property, specifically with patents. And most financial technologies are software-based. Most e-commerce patents are based upon software. So this has a I would say a very huge impact on those technology areas. So this presentation is about 30 minutes long, and it's split up into 3 parts. The first part is going to be an introduction to patents. The second part is going to be a background of the particular area of patent law that is dealt with this particular decision, and kind of a history of how software patents have been given in the United States. And then the last part of the presentation is going to be about the decision itself. So each part is about 10 minutes long, for 30 minutes total. So the first part of the presentation is going to be about what a patent is. So what is a patent? Well, some people may think that patent rights have existed since the Industrial Revolution, or when technologies became more prevalent on the scene. But the reality is, in the United States, patent rights have existed since the founding of the United States and are based upon Article 1, Section 8, Clause 8 of the U.S. Constitution, which essentially provides a limited monopoly of rights to people who discover things and write things, meaning patents and copyrights. And just for a little bit of personal history, the first patent examiner was Thomas Jefferson, and a couple of years later there was a committee that actually examined patents, and that included Thomas Jefferson, Henry Knox, who was the first Secretary of War, and Edmund Randolph, who was, I believe, the Attorney General. So patents have always had a valuable place in the minds of the people who founded this country, and have always had a significant part in the economic development of the United States. So what is a patent? A patent is a property right that is given to an inventor to exclude others from making, using, offering for sale, or selling the invention in the United States, or importing such an invention into the U.S. So a patent doesn't give you the right to make anything. So, you can't go ahead and file a patent application for something, you get that patent, and then say, well, the government gives me the right to do this because of the fact that they gave me a patent. Rather, what a patent is a property right that allows you to exclude other people from making, using, and offering for sale. So one of the areas of controversy within patent law is, I don't know if people have heard about this, but patent trolls, or non-practicing entities, which are companies that don't actually make anything, but what they do is they have a patent and then they sue other companies who are actually in the area of actually doing that technology, making the technology or using the technology. So there's a controversy and debate about what are the economic benefits and also the disadvantages of patents. We're not going to get into that, but that's where it stems from, the right to exclude others. So a patent can be obtained for a machine or apparatus, such as a computer device, for, let's say, a refrigerator, a car. And a patent can also be obtained for methods and systems to perform an invention. So the vast majority of software patents, this would include Fintech as well, have to do with methods. So what you're doing is you're doing a method of performing some act. Maybe it's to send money from location A to location B, but it's all being done on a computer. A method to, let's say, determine signal strength of a wireless communication between two devices is another type of method that can be patented. So what's the process of obtaining a patent? Well, the first step, of course, is that you have to file a patent application with the United States Patent and Trademark Office. So there are a lot of things involved in the patent application, but the substantive portion of the patent application, which is of importance, the three main parts are the written description of the invention, which is also known as the specification, the drawings, and the claims. Now, I did provide 3 handouts. I don't know if the participants had the chance to print those out or look at them, but those kind of show you these 3 parts. So the written description is written generally in normal English, and it provides a very detailed explanation of what the invention is. So it can be 2 or 3 pages, it could be 100 pages, whatever. And then in combination with that, you have the drawings. Now the drawings, in conjunction with the written description, describe the invention, how to use it, how to perform it, how to, if you're making something, how do you make it, how do you manufacture it. And the combination of these two provide the substance of what the invention is. But the most important part of the patent application is the claims. So the Supreme Court has said in a previous decision that the name of the game is the claims. It's the claims that are what get examined when you file a patent application with the USPTO. It's the claims that determine who you can litigate and sue against. You know, if someone infringes on your intellectual property. So the claims are the most important part of the patent application, and it's what gives you the protection. The claims are dependent upon what you have written in the description, the written description, and the drawings. So the written description and the drawings provide support to the subject matter which is in the claims itself. So here are some example claims. So the first one is, these are very basic claims. The first one is a machine device apparatus claim, a device comprising memory, a processor coupled to the memory, and a speaker coupled to the processor for generating audible sound. Now this is a claim that's very, very broad, right? It's a very broad definition. You know, this could be your phone, your smartphone, it could be your computer, it could be your television, it could be a notepad, an iPad, whatever. It's a very, very broad claim. The second claim is a method claim, and these are the types of claims that are generally used with software innovations. So again, this is a very broad example. A method comprising receiving a communication, analyzing the communication, and sending another communication in response to the analyzing of the communication. So these are the things that get examined by the patent examiner at the patent office. They look at this, and as we go through the presentation, I'll talk more about what they do and how they do the examination. So, you know, what happens is that the examiner is going to determine whether to allow or reject your application. And there are three types of rejections that you will generally see. You may see one of them, you may see all three of them if you're unfortunate enough, but these are the three types of main substantive rejections that you will receive. The first one is going to be about the subject matter of the patent application. Is it patent eligible? And this whole presentation going forward is going to be about this particular issue, because this is the issue that Alice talks about, and this is the issue that is under debate regarding software patents. The other two have to do with, is the invention novel? Meaning, is there nothing else exists out there that exactly describes your invention? And is it non-obvious? Meaning that your invention is not an obvious variation of something that already exists. And these are, I'm going to talk a little bit more about these in the next part. So if the examiner stands by the rejection, what happens, or what you can do as the applicant is, of course, you can abandon the patent application if you don't want to proceed anymore. Or what you can do is you can appeal the decision to the Patent Trial and Appeals Board, PTAB, which is an administrative judicial body within the USPTO. Now, if the PTAB decides against you, you also have the option to further appeal that decision to the U.S. Court of Appeals for the Federal Circuit, which is also known in the patent world as the Federal Circuit. This is a specialized court that was created in the 1980s specifically to hear appeals dealing with issues of patent law. So they hear all the appeals that come out of the Patent and Trademark Office, and they also hear all the appeals that come out of the district courts. So for example, if you're in San Francisco and a San Francisco Federal District Court judge decides against you, you don't appeal to the Ninth Circuit Court of Appeals. What you do is your appeal goes straight to the Federal Circuit, and then they hear it. And if the Federal Circuit goes against you, then you have the right to appeal to the Supreme Court. And a lot of the cases, some of the cases we're going to talk about today, that's exactly what happened. Someone at the patent office, they filed a patent application, it was rejected, and it went all the way up to the Supreme Court. So this is part one. So now I'm going to go off to part two, which is really a background of software patenting software, which I call the road to Alice. So I kind of briefly talked about is subject matter patent eligible, or patent eligible subject matter. And that pertains to a statute, 35 U.S.C. 101, which says, whoever invents or discovers any new and useful process, machine, manufacture, or composition may obtain a patent thereof. So for the most part, this has been a very low bar to overcome until Alice. It was very easy. It's not something that's complex. As long as you make something that's new and useful, then it should be eligible for getting a patent. So you have to remember something. Because the invention is eligible for being patented, this does not mean that the invention itself is novel or non-obvious. This is just the first hurdle. So what will happen is the examiner will do a search. This is what examiners mostly do, is they do searches. They will look for other patents, other patent applications, scholarly papers, newspaper articles, etc., etc. And what they're going to do is they're going to try to find something that describes your invention such that it can be rejected for not being novel or non-obvious. So for example, a chair is an apparatus, right? It's a type of device. It is patent eligible, but the chair may not be novel or non-obvious if it already exists in the world and is discovered by the examiner. So if you write a claim, let's say, and the claim says, I claim a chair comprising a base and 4 legs attached to the base, well, what the examiner will do is they will just go do a quick search, find probably a picture of a chair with 4 legs and a base, and say, well, your patent application is rejected because your claim is claiming something which already exists out there. It is eligible to be patented, but it doesn't mean that it's going to be patented. It just is passing the first hurdle of patentability. So before Alice, for a long period of time, probably for hundreds of years, 100 years or so, it was pretty much well known what could not be patent eligible subject matter. So something occurring in nature, like a human being or an animal of some kind that exists in nature naturally, DNA that exists in nature naturally, a signal. The signal came about because of a famous case, I believe it was Alexander Graham Bell. He was trying to get a patent on a signal that was being sent, back and forth between telecommunications equipment, and it was decided that a signal is something that exists in nature, and you cannot get a patent for that. And that's still law, by the way. So if you ever see someone try to claim a signal, you can't do that. You cannot patent scientific principles. So the law of gravity is not patent eligible subject matter. And the third area, and the one that we're going to talk about more, is something abstract. So an algorithm just by itself is not patent eligible subject matter. So if you were to write a claim that said, I claim a method comprising receiving the value X, receiving the value Y, and adding X to Y to give you another value, that would not be patent eligible subject matter. And the reason is because it's abstract. It's not doing anything with it. It's just there. So, the definition of abstract, it's abstract. So you can't get a patent. It's not patent eligible subject matter. So for a long period of time, this was kind of understood. This was the law. If you wrote a patent application, you knew what you could apply for protection for and what you could not. But then in the late 60s and especially in the 1970s, you started to see the advent of computers and computer technology. And as that came about, a very important case came out in 1981 called Diamond v. Deere. Now, I did provide the handout on the actual patent that was issued by the Patent Office, which is Deere, and it's titled, Direct Digital Control of Rubber Molding Presses. So what happened was Deere was the inventor, and what he did was he applied for a patent, and the Patent Office rejected his application. Diamond was the name of the director of the Patent Office at that time. So this case, of course, went all the way up to the Supreme Court, and the Supreme Court decided that this was patent eligible subject matter. And the reason they said it was patent eligible subject matter was because even though there was an algorithm being used, the algorithm was being used by a computing device in a useful process to do something, which was to transform raw rubber material into some sort of manufactured rubber material. So there was a useful result. So it wasn't abstract because it wasn't just an algorithm, there was much more going on. So that and some other cases, started to support that. We're not going to talk about those. So for about 15, 16 years, of course, software innovations continued to occur. They became more and more so. And in 1998, another decision came out, and this one was called State Street Bank versus Signature Financial Group. And this was a decision by the Federal Circuit. It never went up to the Supreme Court. The Federal Circuit, it was their decision. And what happened was, in this decision, was that you had a patent that was given by the Patent Office for basically determining the price of a portfolio for a stock price. That was really the gist of what the patent was about. And the Signature Financial Group, it was their patent. And what they did was they sued State Street Bank. And of course, there was a contentious, litigation between the two. And it went up to the Federal Circuit. And the Federal Circuit said that this also is patent eligible subject matter. And the reasoning was they went back to the first case we talked about, which was Diamond v. Deere. And they said that what is going on here is that there is a practical application of a mathematical algorithm, and it produces a useful, concrete, and tangible result. And that tangible result was the final share price. And also what the Federal Circuit said was that there's a transformation of data. So instead of a transformation of some physical material, there was a transformation going on of data itself, taking raw data and then calculating some price and providing an output. So by using the reasoning in the rubber molding manufacturing process patent, the Federal Circuit said this is also useful, it's not abstract, and therefore you should be able to get a patent for that. So what happened was, from 1998 until the mid-2000s, you had the floodgates basically opened, and you had a substantial number of patent applications being filed for what is now known as business method patents. So, I was at the Patent Office at that time. I worked in the financial technologies area, but there were also examiners who were hired and they exclusively looked at insurance technology patents, and there were others that looked at operations management and advertising and e-commerce. So it was just a huge number of people were now, and companies were now looking and seeking patent protection for business method patents. And what you guys do, a lot of what you do in FinTech, of course, is business method based. So that continued on until, of course, then there was a feeling that, well, maybe, there's too much of this going on and there may need to be some limitations. So in 2010, another case came out which kind of took the dial back a bit. And this was Bilski versus Kappas. Bilski was the inventor. Kappas at that time was the director of the U.S. Patent and Trademark Office. So Bilski had applied for a patent for basically hedging losses by investing in one area versus another area, right? And, it's like if you decide to buy a put versus an option, you're hedging against one or the other depending on the stock market is doing. Notice the stock market is doing so hot today, but that's basically the gist of what Bilski's invention was. So the Patent Office said that this is not patent eligible subject matter, and the reasoning was that the claims that Bilski had, the claims did not have any machine or computing device performing the method steps. So when this went up to the Supreme Court said was that this is an abstract idea being given because there's no machine or computing device in the claims. So they said this is not like Diamond v. Deere, and it's not like State Street Bank where you had a computer being involved or some sort of transformation going on. So therefore they said, okay, the idea of abstract is that if it's not being done by a machine or transformation, then that's an abstract idea. So they changed the definition of what an abstract idea is, and they created a new test called the machine or transformation test. So, just a kind of a question at that time that people had was, well, does the transformation of data really that occurs within a computing environment, does that really comply with transformation? But that never mattered, because what happened was was that you had another out versus the transformation, and that was the machine. So remember this claim, a method comprising receiving a communication, analyzing it, sending it. Under 101, under Bilski in 2010, this would fail 101. It would be considered abstract because there's no machine or transformation going on. So what did all the smart patent lawyers in the world do, and what did the Patent Office accept was okay to comply with the Supreme Court decision? Put in a computing device. So one of the things about a claim is you can change the language in a claim, but you cannot change the language or you cannot change the drawings in a patent application. So, and that's going to be important about something I'm going to mention later on. But you can change the claim. So what you could do is, as long as your application, the description or the drawing showed a computer, you could amend the claims to show a computing device. So this passes under 101 because now there's a machine. And this was the law until 2014 when Alice came out. So Alice, the background about Alice is Alice Corporation is an Australian company. They had 4 patents, and these patents had to do with a process of financial trading between 2 parties and having a third party being involved to reduce settlement risk. I printed out one of the application patents. It's under the title The Inventor Shepherd. And what Alice did was they went after CLS Bank. CLS Bank sued them in district court to invalidate the patents because CLS Bank, their lawyer, said that this is not patent eligible subject matter. The district court found that the patents were not directed to eligible subject matter. They are patent ineligible and invalidated the patents. So Alice then, appealed to the Federal Circuit. The Federal Circuit has 9 judges total. En banc, they all heard the decision, and they came up with 7 different opinions. So none of them could agree about whether the claims of the Alice patents were patent eligible subject matter. So of course what happened was the Supreme Court took up the decision. And the Supreme Court decided that the claims were directed to patent ineligible subject matter. So what the Supreme Court said was they again changed the definition of 101. And what they said was that simply adding a general computing device does not change ineligible subject matter to eligible subject matter. So what they did was they created a new test. Basically what they were claiming is that they expanded on the machine or transformation test, and it's a 2-step process now. So first they ask, is the claim directed to an abstract idea? So remember at the beginning, what did we say was an abstract idea? It's just simply an algorithm. Well, now they've expanded the definition of what an abstract idea is, okay? Kind of like what a lot of lawyers and court cases do. You think a word means something, but now it means something else within a particular area of the law. So an abstract idea now is an algorithm, a computer process, or general principle. A general principle may be buying and selling things, bartering. That's a general principle. If so, does the claim, remember this is about the claims, not what's in the specification or the drawings, does the claim include something which is significantly more? Now, what has been determined is that significantly more means, is there a technological innovation in the claims? So remember this, receiving by the computer, analyzing, sending. Under Alice, this is abstract. Is there something extra? No, because the computer is a general computer and is not an inventive concept. So what happens now is the examiners in the courts, what they will do is imagine in their minds, they will draw an imaginary line through a general computer recited in the claims, and they'll look at it and say, well, can this thing be done by a human being? And if it can be done by a human being, it's considered abstract. What the court said, the Supreme Court said, was they don't care how innovative it is or how unique it is. If it's not within the technological realm, if it's not directed to something technological, then it is abstract. Okay, so they changed the definition of abstract. Now, they did say that you can still apply for a business method patent. You can still file them. But the issue now, of course, is that what the Alice decision has done is to significantly change the parameters of what can be patented. What you now have to do in the claims is you have to show something which is technologically innovative and not something that can simply be performed by a human being. So what does this mean? So what this means is that the meaning of abstract is beyond the normal meaning and definition of abstract. An abstract idea in the patent world now means is you're claiming something that can be done by a human and only includes general computing technology. You have to show a claim that actually shows something which is technologically innovative. It can't be just, putting in by a computer, sending by a computer, doing by a computer. One of the things that happened, just to let you know, is when Alice came out, when your patent gets examined, if they allow your patent, they'll send you a notice of allowance, the patent office will. And what happens is you have to pay an issue fee. So there's a period of time between when you get the notice of allowance, you pay the issue fee, and then your patent becomes published. Once it becomes published, then you have the actual patent. What happened was that Alice came out at a time where there were people who had paid the issue fee and they were just waiting for the patent to be published. And what happened was Alice came out and the patent office took back the allowances, they refunded the issue fees, and they told all these poor souls who, the patent process takes anywhere from 2 to 3 years, that Alice has come out, we have to now re-examine your application under Alice. And what happened was that a number of people out there, they had written their applications and their claims based upon what? On Bilski. So all they had was a general computing device in the claims. And they didn't have anything in their specifications or drawings that went into technological features or innovations, because all their specifications and drawings were based upon what? Based upon innovations that had to do with business solutions. And the Supreme Court has said is we don't care if it's a innovative business solution. If it can be done by a human being, that's abstract. It has to have some sort of technological innovation feature to have it be considered patent eligible subject matter. So as a result, the Patent Office issued new guidelines, and as a result, of course, this resulted in a huge number of one-on-one rejections occurring. Before Alice in financial trading, 23% were rejected under Alice. After Alice, 88%. In e-commerce, 30% were rejected under one-on-one. After Alice, 85%. Now, this doesn't mean that, the rejections, they weren't able to respond to the rejections or overcome it. It just shows the huge growth of rejections that occurred because of the fact that Alice went in the opposite direction of State Street Bank and Diamond v. Deere and made the bar for one-on-one much, much higher to comply with if you're trying to get, some sort of software innovation or some sort of business method innovation for sure. So at the Federal Circuit, 70 out of 77 patents have been found invalid under 101. At the district court level, this is, up to this time, 2017, about 222 decisions have invalidated patents and 137 have upheld the patents under 101. So at the district court level, you're looking at about 60%. The issue, of course, is that Alice hasn't stopped at business methods. It also has affected other areas as well, like medical technologies, automotive technologies, telecommunications technologies, because, if you think about it, automotive technologies, if you don't write the claim correctly or properly under Alice, the examiner could argue, well, what you're doing in the claim can be done by a human being. It's not something which, complies with Alice. So this has really changed the way, or should have changed the way, how patent applications are written. So what a good patent attorney should be doing is they should be looking at what are the technological innovations, and there are always some technological innovations, there should be, associated with your fintech or business method innovation that you can put in the claims. So one of the benefits I would say is, and this concludes my presentation, but one of the benefits of, you know, having this decision come out before you file a patent application is that your patent applications are going to comply, hopefully, with Alice. Those people who filed a patent application before Alice, they cannot change their drawings and they cannot change their specifications, so therefore they're stuck. And if your patent was allowed before Alice, you also have a problem because you can't even change the claim. It's an issued patent. So you're going to run a higher risk of invalidation if you ever decide to enforce your patent at a district court level or take it before the Federal Circuit. So I hope that was informative, and if anyone has any questions, I'd be glad to answer them.
Thank you so much, Abdul. That was a really helpful presentation. Turning it now over to our attendees. If you have any questions, feel free to chat them into the chat box on the GoToMeeting kind of portal there, or I will unmute all of you on my end. So if you would like to verbally ask your question, feel free as well.